Every panel will be chaired by an eminent academic or practitioner or both, in this case, both. So Professor Philip Capper, I've already mentioned him, of course. He's now an emeritus professor at King's, but he held a number of other, and Philip, if I may, I will focus on your academic achievements in the first place. He's a former chairman of the Faculty of Law at the University of Oxford. He was Nash Professor of Engineering Law here at King's College London at the Centre, and he now continues to be at King's at the Centre as an emeritus professor. But very just quickly to say, as you all know, he's also the head of International Arbitration and White & Case LLP in London, and considered one of the leading construction dispute lawyers in the world. So I'll now hand over to Philip for the panel. Just before doing that, I remind the online audience that during the Q&A at the end, you can also ask questions. Please type your question in the Q&A space, not in the chat space, please, and I will do my best to ensure that some of the questions, at least from the online audience, are asked as well. Philip.
Thank you very much, Renato. It's impossible to exaggerate the sense of honor and pride and privilege, shared pride, that we should be in this room 35 years on. We had a party out in that quad just over 35 years ago, and several of you, perhaps many of you, have heard me tell one story which I'll tell again. I've told it before. A great giant of construction law, Humphrey Lloyd, came to the party. The party was to announce that this centre was to be formed. And such is the gossip around construction law that has never stopped. He already knew, I don't know how, that John Uff had persuaded me to leave Oxford and come here for this centre. And Humphrey stood out in that quad and he said, "This is wonderful, you'll get quite a lot of students in the first year, but what will you do in the second year?" Well, the answer to Humphrey is that in 35 years, we have had 1,300 master's graduates pass through this centre. And that doesn't include the graduates of other institutions that are either directly flowed from here, whether in Singapore or Dubai, or indeed other institutions, I'll mention another later, where there has been a sort of growth into another place, and that's all rather wonderful. That success is very much the consequence, as Renato has already said, of that vision and first directorship of John Uff, which is quite wonderful, and it's been brought all the way through. And to have John now this afternoon speaking at this conference, just as we had that conference way, way back at the beginning, is a wonderful thing. We've been blessed with several, as you have heard, excellent directors, and each has brought us something different. I want to pay particular tribute to Philip Britton, whom I persuaded to come and join us here, and I'm delighted that he did. In three particular ways. It was Philip that put a really solid framework around our academic offering, and he made sure that the students had all the guidance and the notes and all the things that could help them, which has placed everything in the right shape. But secondly, it was Philip who led our growth into Singapore and into Dubai, and he's gone on to foster relationships in Australia and elsewhere. And then thirdly, the relationship with the Society of Construction Law, which of course predates this. If I remember rightly, John, it's 40 years next year. I think it was 1983 that we were sitting up in the RIBA premises, launching the Society of Construction Law. But Philip's directorship particularly strengthened our relationship too with the Society of Construction Law. And just jumping for a moment, of course, it was Philip and I that supervised one of our PhD students. We've had many successful PhD students. But of course, one of those PhD students, I'm pleased to say, of course, was successful. And he is David Mosey, now Professor David Mosey, and we're delighted that he has come to our centre as a professor and director, and I'm going to come back to another in a moment. But of course, David has broadened our appreciation of the field, because John and I, for obvious reasons, are much more interested in disputes, if I may say so, or at least interest is the wrong word, much more involved in disputes. And there was a sense in which the King's Centre was always looking rather more at the disputes end of construction law than the front end of project strategy and so on. And David's contribution in that field has been immense and recognised, as you know, nationally and internationally. But throughout all of that is the wonderful service of our loyal and other director, John Barber, who has been our Michael Brown lecturer, and probably no one has spent more time looking after our students and giving of his own time and service. And it's part of the whole offering that our centre has enjoyed by the gift of time that comes from so many. Nicholas Gould is another who has served us throughout with the gift of time, and it's been able to be reflected, not just in 1,300 graduations, but all the many other activities at our centre. I'm absolutely delighted that one of our earliest students, Professor Paula Gerber, is here. She's agreed that I can call her course a daughter course of ours. It's not the only affiliated course in the sense, but she was here and she took what we had back. She's no doubt made it even better. But it's great that there's been this proliferation around the world of what we sought to do here 35 years ago. So it is therefore, for me, a tremendous pleasure that one can now think about that 35 years and see what's happened along the way, with immense thanks to all that I've mentioned, together with, most important of all of the students. You know, when we started, there was no real connection between law schools and practice. There was no real engagement in multidisciplinary study in universities involving law and other disciplines. Now these things are regarded as to be desired. But 35 years ago, what John had the vision of and what has been delivered was quite remarkable, and I'm delighted that it's succeeded so well. So let's turn then to our first session this afternoon, and we're going to talk about construction law, the past, the present, and the future, which is itself rather a large subject. I'm going to introduce each of the speakers, I think, now, so that they can then hand over to one another as they move through the ages, in the moment past, and then moving on to the future. First, John. Well, John's had many introductions this afternoon, and in a sense, he is truly one of those that needs no more. But he was, of course, not only our founding director, but was already a wonderful example of one of those originally an engineer become barrister, which characterizes much of what we have in London by way of leaders in construction law. It's already been mentioned that he was the Nash Professor of Engineering here, and I was honored to succeed him in that. But he's maintained very close contact with the engineering world subsequently, with the ICE and the Royal Academy of Engineering, but he's also been an officer of and a great supporter of the LCIA in the context of international arbitration. He's been a president of the Society of Construction Arbitrators and a master of the Worshipful Company of Arbitrators. Then we're going to turn to Kim Franklin. Kim is a specialist in construction, engineering, and infrastructure sectors, of course. She sits now predominantly as arbitrator, but also as dispute board member and adjudicator, and she's been appointed in so many different institutional contexts. She's been a QC, now KC, since 2016, and of course she has the flair necessarily for the heavy disputes with which we're all familiar. She's served as committee member in a number of too many places to institutions to list. But I will say this, that Chambers said of her last year, she is very sharp and commercial, but also pleasant to deal with. She has everyone eating out of her hand. So if there are two warring parties, Kim as arbitrator gets them to cooperate and calms everybody. Well, she's going to follow John Uff, and therefore that's will work out well, because she's going to look at the next 35 years after John has looked at the development over the past 35. You've already been introduced to Renato, and he's the director I didn't mention. It's so good that we have reached a point with this centre that we have someone of the stature of Renato coming from a chair in another UK university, becoming our director, and with his staff and faculty taking this forward for the next 35 years. Perhaps not himself, but nevertheless, we are delighted. And of course, he has great specialization, not only in international arbitration, but he also is a very distinguished lawyer in the field of competition and has held important positions in that regard during his career. He's also a partner of LMS Legal LLP. And then fourth, and I should say, Renato is going to speak on English construction law in the international market. And then we turn to the role of international courts in construction disputes by turning to the Honourable Mr Justice Waksman. David Waksman was called to the bar in the Middle Temple in 82. He practiced in commercial law and became what is now a KC, a QC then, in 2002. He's been a Deputy High Court judge, and he's been the Specialist Senior Circuit Judge in Manchester. But in 2015, he became judge in charge of the London Circuit Commercial Court and appointed High Court judge in 2018. He's assigned to the Queen's Bench Division, now King's Bench, of course, but importantly, not only does he serve in the commercial court, but he does in our technology and construction court. So, ladies and gentlemen, welcome to our conference. These are our first four speakers. John Uff on the past 35 years and its development, Kim Franklin on the next 35 years, Renato Nazzini on English construction law in the international market, and then from David Waksman on the role of international courts in construction disputes. Thank you, all four of you. John.
Well, thank you very much, Philip. And you'll be glad to hear that's the end of the introduction. We're now going to turn to the subject of this conference, which is construction law. I was asked to write about the development of construction law over the life of the King's Centre, 35 years. And being a traditionalist, I wrote a paper which I think is not yet with you, but I hope you don't have to wait to buy the book in order to get the paper. Perhaps that could go on the website, Renato. But there is a full paper there. When I ran the conferences here, the rule was that you produced a full paper and that was published for the conference, but I'm afraid you'll have to wait a little bit for that. So, developments in construction law over the life of the King's Centre. There's one huge development that I should put right up front, and that is the way in which construction law has become a mainstream legal subject. Certainly since the 1980s, construction law has been a major generator of commercial law, and without doubt, even by the 1970s, it had overtaken shipping. But recognition within the legal profession has been curiously delayed. Most people in the 1980s, if you spoke of construction, they thought you were talking about construing documents in the Chancery Division. I'm glad all that has changed, but construction law was held back, we should be frank, by the apparent second-class status accorded to the official referees and their courts where the law was all generated. And it took another 2 decades or so before that was all changed. But fortunately, the TCC is now firmly led by High Court judges, including Mr Justice Waksman, who rank alongside or even ahead, depending on your viewpoint, of the Commercial Court and the Chancery Division. And that is a huge development in that construction law is now recognised throughout. Philip has mentioned the Society for Construction Law, which predated us by 5 years, almost exactly. And it was the Society for Construction Law that I think established the appetite for construction law amongst the mixed professional intake that we have developed. But it immediately became apparent that construction law wasn't something primarily or exclusively for lawyers. It was something that was of interest to quantity surveyors, architects, engineers of all stripes, and that was the situation that we inherited and took the somewhat bold move of adding the academic dimension to it, if you like, setting up a qualification course, and then eventually persuading London University, as it then was, that this merited the award of a master's degree, and because the LLM was already established, and because of the nature of the subject, we decided to call it an MSc, and so it has been for just under 35 years. So that was a great development. But to talk about the development of construction law, I'd like to turn back to the first annual conference that we held in this very hall, and I was very pleased a few moments ago to see my old friend Jeremy Winter walk into the hall. Hello, Jeremy. Because Jeremy was our first sponsor. Now, the decision to launch a full-scale conference in 1988, 1 year after the centre was founded, was an act of faith. Let's be clear. We weren't quite sure if anyone would turn up. And that conference was, I think, virtually the first academic conference ever held in construction law. And to show that we weren't afraid of failure, we ran it over 3 full days, almost unheard of these days. And we invited everyone, the judges, the practitioners, the construction professionals, and they all came. And you can still get the collated and edited proceedings of that conference in the famous Blue Book. We called it Construction Contract Policy. And in the course of planning the conference, we chose, I should probably say I chose, because I take full responsibility for having got some of it wrong, apparently. I selected the subjects that I thought were those that really engaged with construction law and would be the subjects of the future. And those subjects, the various parts of the book, were as follows: risk assessment, project management, quality control, control of time, and payment issues. And it's interesting to look at those topics and see what's happened to them. First, risk assessment. That was genuinely thought to be one of the key factors in the successful organisation of contracts. But anyone who's read into risk assessment recently will realise it's a subject still waiting development. So, as I often say to students at the centre, anyone who's looking for an interesting dissertation subject, there it is. Lots of papers. There's a couple of very good papers in the Blue Book, all about risk assessment, which I still think is an important subject in construction law and still awaiting development. Then the second topic, project management. That was really a subject designed for Martin Barnes, whom I always hoped would join us at the centre. He never did, but he continued to follow our development. He was at the time heavily into developing the NEC forms of contract that he wrote all himself. And the basis of that was that contract performance is dependent on successful project management. I suppose you'd say he would say that as a project manager, but he had some very interesting ideas. He worked out a theory and rules of project management, one of which was that you can only manage things that haven't yet happened, which is quite profound if you think about it. We spend so much of our time analysing things that have already happened and gone wrong. This was a major theme of the NEC forms of contract, but like my first topic, it still awaits development. So anyone who's looking for an interesting, any of you students who's looking for an interesting dissertation topic, think about project management. I wrote a paper not very long ago for the Old Students Association suggesting that the ills of the UK construction industry, which incidentally has one of the worst productivity records in the world, what was needed was a bit more project management. So there's a theme for you. So the third theme was quality control. This is a topic that has been in and out of the headlines for a long time. Various governments have addressed the subject. At one point, we had quality assurance thrust upon us as though that was going to solve all the problems of quality. It solved some of the problems, but of course not all of them. And looking at quality management, one can see two opposing trends. One seeking to tighten up enforcement, and the other seeking to relax prescription. Among that category being the removal of the independent engineer from construction projects, and most of the engineering disasters that have happened in the last couple of decades could well be attributable to the lack of an independent controlling engineer. But that's a big debate, which any of you can pick up for your dissertations. One attempt to address public concern about quality management was addressed by a DTI working party in which quite a number of personnel from the Centre for Construction Law played a major part, including Phillip, myself, Donald Keating, who regularly visited the centre, and as chairman, Professor Donald Bishop, the late Donald Bishop, who was a great supporter of the centre and gave up a great deal of his time. He was professor at University College, but nevertheless found a home with us and spent many, many days talking to our students about writing their dissertations. So that working party came up with a proposal for latent defects in something called Building Users Insurance Against Latent Defects, which spells BUILD. BUILD insurance was based on the French decennial system, and the report was accepted by the DTI, and the industry took great interest in it, and BUILD policies were available throughout the industry. Sadly, it never became mandatory. Had it done so, it would have provided the solution to many later tragedies, including all those now unsaleable buildings resulting from the Grenfell Tower disaster. The report is still there on the website, and there's a reference in my paper that you can look it all up. And it is still awaiting implementation, so another dissertation topic. Then the control of time. We spent a lot of time talking about the control of time. And looking back, it's interesting that while extension of time clauses in standard forms have retained the same technology, same terminology, often using the same words, since the founding of the centre. In terms of delays to construction, those have also, of course, remained with us, but the analysis of delays has moved into a higher sphere, as we all know, becoming ever more sophisticated, involving more and more computer programs, and with new concepts being developed, such as the concept of concurrent delay. So lots of new analysis there, but no change in the problem. Then payment issues. Payment, strangely, or perhaps not strangely, remains largely in the hands of our quantity surveying brethren, applying their traditional skills. As projects grow bigger and more sophisticated, the demands for their services continues to grow. There might seem to be an exception with target cost contracts, which are subsequent to the founding of the centre. But in many ways, these create even more complexity with the complicated arrangements which are devised to spread the pain and the gain between the parties, so that, and particularly where delay costs are involved, we end up with a highly complex quantum problem, which again requires the quantity surveyors to solve for us. A few years before the centre was formed, the problem of the perennial problem with cash flow was addressed by the Court of Appeal in a famous decision in which they decided that the solution to cash flow was to look at architect certificates, which they decided should be treated virtually as bills of exchange. An interesting example of the Court of Appeal thinking that it sees the answer that had eluded everybody else for centuries. In Dornay's and Minter, they suddenly decided that the architect certificates were to be regarded virtually as cash, and that remained the law, amazingly, for some 4 years before the issue reached the House of Lords and was then reversed. But it indicated an appetite to try and solve this problem of cash flow and the maintenance of money moving around the construction industry. And that leads me on to the subject of dispute resolution, which strangely wasn't seen as a mainstream issue in the first annual conference, but was picked up in quite a number of subsequent conferences. And the development of dispute resolution can be seen first as a response to dissatisfaction by contractors with what I might call the rule of the engineer, which was the position right up until the well into the 1990s, and indeed up to the advent of the Construction Act. During the 1990s, there was also a wave of insolvencies, which led to the setting up of the Latham Inquiry and the Construction Act. The passing of that act was not a matter which was the subject of the sort of extensive debate that you would expect, anything approaching the debate that has surrounded the very modest proposals to amend the Arbitration Act, for example. It was a political decision, not made at the behest of professional institutions, but driven by the fact that the government under John Major had lost its majority in Parliament. In my paper, which you will see at some point, I draw a parallel with the two acts that went through Parliament on that basis at the same time, Construction Act and the Arbitration Act 1996. I had the privilege of being amongst the construction people who were on the DAC and contributed to what we saw then as the problem to cash flow in the construction industry, which was Section 39, which provides for provisional awards or orders to be given by a tribunal that then continues to retain its position and if necessary, issuing several other decisions, rather like serial adjudications, but with the same tribunal. I address this in the paper that you will see at some point. This is not the time to debate the relative merits of adjudication and Section 39, but that is a debate that should take place at some point. And again, if anyone's looking for a dissertation subject, I offer it for your consideration. It's interesting that the Law Commission is proposing some very modest amendments to Section 39, which do not address the substance of the of the section, but merely one or two of the words. And in conclusion, after the Construction Act came in, I recall it being suggested that the Centre for Construction Law might just as well wind itself up, because the only subject that anyone in construction law needed to know about now was adjudication. And fortunately, no one took that seriously, but there is certainly a view that adjudication itself has a lot to learn from construction. But again, that's a topic for a dissertation. And so construction law continues to develop, driven by changes in the industry itself and various attempts by the professional institutions to improve matters. The industry remains substantially self-regulating and subject to legal intervention only to the limited extent of the Construction Act. The institutions themselves, with whom we have throughout maintained very close relations, retains an important self-regulating role in training and qualification. This makes the role of the Centre for Construction Law more vital in promoting the right balance between the various sides of the profession and the constituents of construction law to the benefit of the whole construction industry. Thank you very much.
Thank you very much, John.
And I think I now have to introduce Kim Franklin, who's already been introduced.
Will that just bring them? Yes. There we are. Brilliant. Terrific.
Thank you, Kim, and welcome.
Thank you very much. What an honour it is, although I have to say quite a spooky one, to be asked to look into the future of construction law and the resolution of construction disputes for the next 35 years. I qualified in the 1980s, and I've rather travelled the path of the last 35 years together with King's College. And 35 years ago, I was reminded at last night's speaker's dinner, I had just joined Mr Justice Waksman's chambers. And there's a chance, I might be around in 35 years' time to see just how badly I got it wrong. Now, you only need to consider the changes in the last 3.5 decades to see what a challenge it would be to predict the world in 2057. Who would have foreseen BIM, Bitcoin, Bezos, and that's just the bees. The scope of construction law has expanded, as John Uff has so ably explained, from absolutely nothing to cover infrastructure, oil and gas, power, computers, ships, and even aeroplanes. And I have to make a caveat that I am actually rubbish at predictions. I was on the SCL committee in the 1990s when its lunch was first mooted, and I voted against it. I said no one would go. I even volunteered to speak, and I was genuinely surprised when 30 people signed up. It now hosts over 1,400 guests, with tickets selling out quicker than Glastonbury, which has been going only marginally longer. But look, help is at hand. Wasn't it Abraham Lincoln who said, the best way to predict the future is to create it? The best way to predict the future is to create it. So now I'm warming to my task. What sort of future would I like to see in the 2050s? Sadly, I've only got 20 minutes. So I'm going to pick two themes to have a look at. One is artificial intelligence, and the other is green. Now, AI sends a shiver down the spine of all warm-blooded lawyers. I'm making an assumption there. You've probably spotted it. Richard Susskind, he's a guru on this subject, and he's written a book called Tomorrow's Lawyers. And he says that we're facing greater change than we've ever seen in the past 2 centuries. He says the future's going to be an internet-based global business with online document production, a commoditized service, a legal process outsourcing, web-based simulation practice. He says the market is going to be liberalized, new jobs for lawyers and new employers too. That's what he says. And he's an educated and well-informed chap. What do the headlines say? The robots are after your job. And that's where we get the shiver down the spine. And then if you listen to Richard Susskind speak, he says, well, don't worry, it'll see you out beyond your retirement. And then there's a modest giggle goes through the room, and he says, that's the only time I get a laugh. He predicted that there would be an increase in virtual hearings and online dispute resolution, and these have happened. They've happened without fanfare or objection. And one of the features of the job that we do in construction law is the volume of documentation. The use of emails since the 1980s has caused a proliferation. Back then, I went to a seminar which was promoting the paperless construction project. All exchanges would be recorded in digital format. There, they said, there will be nothing to argue about. I was a bit depressed in the tea break when a seasoned lawyer came along and said, oh, don't worry, we'll be still arguing about what these digital exchanges actually mean. And so we are. Reading documents for discovery was something that juniors did. As a barrister, I was sent off into rooms full of boxes to flag up documents for disclosure, and I'd be gone for weeks. Now documents are read by paralegals, they're scanned by machines, or, and this is the cynic in me, to suggest they're not read at all. E-disclosure is a thing, search terms are argued about as much as the merits, and mistakes are made. If the project name is that of a location, it throws up all the discussions about site visits, all the travel arrangements, including the stag do's. But you might say, well, isn't it a good use of resources for voluminous documentation to be scanned by machines rather than paralegals who have a limited understanding of the issues and absolutely no interest in the outcome of the case? And this was demonstrated when, as tribunal, I asked for a consolidated index of all the hearing bundles which had been prepared by different teams. This master index identified numerous duplications. Well, no surprises there. But more surprising was the different descriptions which were applied to the same document by different people. Now, a machine wouldn't have confused a method statement with an amended schedule or a contract appendix. It would just have called the document A11/428B, I suggest. So here's the thing. Humans find repetitive tasks boring, but they excel, they even enjoy high-skill, complex, varied tasks. By contrast, a robot can cut the lawn because all lawns are the same. It can't be a gardener because no two gardens are the same. So a robot could demolish a wall, but it couldn't run a project. So I suggest in the future we're going to see an increase in the use of machines. They will free up construction lawyers away from the drudgery of documents to do their job. They will define the issues, research the law, analyze the evidence, advise the client. This will improve legal services away from quantity to more focused quality. Increased analysis by thinking lawyers will produce focused evidence, fewer documents, shorter hearing bundles. Oh, happy day. Well, let's think about a couple of things as we envisage this future. Although naturally conservative, both the construction industry and the legal professions have adapted around the lockdown constraints of the pandemic. My fellow lawyers, they are a capable, intelligent lot, But I was impressed by how rapidly the law firms responded to enable business as usual after March 2020. Let's think about cost. All this tech does not come cheap. Initial investment is high. At the moment, paralegals are the cheapest robots around. But in the future, entry-level lawyers will have new skills. They will know all about e-discovery. They will know about cybersecurity and project management. They may even program the robots. They will enjoy their jobs. Legal tech will dominate the future. I'd put money on it. In fact, I think I probably will. Now, my second theme for the future is green. The legal profession is vilified for a lot of things, but it's not seen as a key contributor to greenhouse gases. There are aspects of construction law, however, particularly international arbitration, which are particularly wasteful. The typical international arbitration uses the carbon equivalent of not 21 or even 1,000, but 21,000 trees. The key culprits are buildings, printing, and flying. Now, these have been identified and tackled by the Campaign for Greener Arbitrations. The campaign was launched by Lucy Greenwood, and yes, that really is her name. Its intention is to minimize the impact of arbitration on the environment, to increase awareness of waste and unnecessary travel, and it's reached out to all stakeholders, not just lawyers, the institutions, the law firms, the venues, the third-party funders, the conference organizers, journalists, technology providers, and of course the clients. The pledge, which you can look up and sign, includes a commitment to reduce energy consumption at work, to use electronic communication, to avoid printing, and unnecessary travel. And there are protocols, there's a whole suite of them for arbitrators, for law firms, and for chambers. And there is a draft green procedural order, which again I commend to you. Green habits, of course, start at home. Construction disputes don't happen without people. You usually need at least two. And they have behavioral habits beyond their case. So we can all reduce and we can reuse and recycle. I'll give you a little example. I'm a well-known skinflint. I'm probably the most skinflinty person, with the possible exception of my mother, that I know. And I read this headline that Currys had reported that as a result of the energy crisis, their national showroom electricity bill was increased by £8 million year on year. So this year it was £8 million more expensive than last. And how did they respond to this, Currys? Well, they turned down the brightness on their television screens. You can save money by turning down the brightness on your television screen? Who knew? And green, well, it's not all or nothing. So it might be said that you can't sign the Green Pledge if you work in the Middle East. I flew back from Dubai yesterday to be with you today. So look, I did look into the alternatives, all right? You can travel overland from London to Dubai. Getting the train to Istanbul is reasonably straightforward. After that, the coach across the desert is less attractive, particularly as it takes 3 days. This is nothing compared with the 70-day bus trip from London to Delhi. So the protocol doesn't say don't fly. It says avoid unnecessary travel and select environmentally friendly travel alternatives. Flights to Dubai are necessary if you work there. You don't have to travel business, though. And the combination of space and weight leaves a larger footprint than traveling in economy, up to 3.5 times. It's more profitable. The airlines have an incentive to offer more expensive seats and carry fewer people less efficiently. It's a complex subject, but the more expensive the ticket, the higher the emissions. And business class is like the SUV compared with economy's hybrid. Now, I'm just going to pause there and say something about my slides. I expect you've been very impressed with them. And as I did them on my PowerPoint, and I put the material in, there's a little box at the side which said, wouldn't you prefer them to be presented like this? And they did rather a good job, I thought. When I got to this one, it was completely flummoxed. It had no idea what I was trying to say, and that rather makes the point about computers. No sense of irony, nothing subtle about their thinking. The protocol, the agreed protocol, includes for providing offsetting carbon emissions. And this is the text of it. Arbitrators may include the cost of offsetting their flights in their expenses. The parties agree that costs of offsetting air travel may be allocated by the tribunal as part of the costs of the award. So pop those provisions in your terms of reference. It's a sure way to check that the parties have read them. I predict that green initiatives will create a virtuous circle with companies, law firms, and individuals requiring and competing for green credentials. Ultimately, the most efficient carbon-neutral construction dispute is no dispute at all. And that's not going to happen. I'll definitely put money on that. So here's my conclusion. Create your own future, get savvy with the tech, enjoy your job, have the green initiatives, and compete for status. So I've reassured you that AI will make your job more fun, and that yes, you, each one of you in this room, you can save the planet. You're going to ask me, where's all the work going to come from? I mean, you're going to say it's not just going to fall from the sky, is it? Well, it turns out that it just might. Chatting to people in Dubai, I've got a new networking intro. It's not, oh, hello, how are you? Are you busy? I say, what's going to happen to construction law in the next 35 years then? That gets them thinking. So there are satellites up there which are not doing what they should. Challenging, hey? Where's the expert going to come from? What about a site view? Bits of space debris fall to Earth and cause damage. One day it will be serious. What will the insurers say about that? I was going to say, and it won't be long before we're off to the moon again, and I got back and turned on the news, and it turns out we're off to the moon again. Who owns it? And what about its minerals? We might even be off to Mars. I'm not going to put money on that, and will probably regret it. Out in Dubai, ESG is the new buzzword. E, environment, S, social, and G, governance. There's just lots of these ESG disputes even now. There's a recent $20 million deal between the US and Indonesia to fund the shift for Indonesia's shift away from coal dependency to renewables. So what if Indonesia doesn't stick to the deal? Or what if the renewables don't work? There is a dispute now between Egypt and Ethiopia over the building of the Grand Ethiopia Renaissance hydropower dam, which is built across the source of the Nile. Cairo wants to do a deal with Addis Ababa so that the flow of the water can be regulated into the Nile Delta, upon which most of the inhabitants of Egypt depend, that water can flow during the times of drought. Addis Ababa are not taking that call. Water will become the next battleground. There's either too much of it, we get flooding, or there's not enough of it, we get drought, or it's poisoned. Here in the UK, our rivers and coastal regions are polluted by our own water companies. The environmental agency who should regulate them is powerless. Individuals are championing the cause, and they will be the ones who take the government to court. There are claims for climate justice, compensating those who have contributed least to climate change, but who are suffering the most. And all these issues will be addressed by those young, enthusiastic lawyers armed with robot technology and with a stake in their future. So in 35 years, I look forward I'll be in my 90s, And I want to reflect on these predictions from the comfort of my care home, where I will be looked after nicely, with any luck, by a robot. Thank you very much.
Thank you very much. Thank you very much, Kim Franklin. So we turn now to Renato Nazzini.
Thank you very much. And my task is to look at English construction law in the international market. And what do we mean by that? Or what was the idea of that? Also developed over a bottle of wine with Julian a while ago. Well, I thought I should construe this title, or this idea, looking at three things, really, in three areas. The first, but very quickly, is the use of English law internationally. There is some evidence in relation to that. Construction law is part and parcel of English commercial law more broadly. Then the second thing I look at is the choice of English law, English construction law in the international market, so parties choosing to govern their contracts abroad by choosing, as I said, English law. And thirdly, which possibly is actually the most important aspect of the role of English law in the international market, is the influence of English law on construction law internationally, so also other laws or contracts or projects governed by other laws, but where commercial English construction law has had an impact in one way or another. So just a quick word about the use of English law internationally. I mean, it's pretty well known that English law is very often the law of choice, the law to go to for any international contract. And in 2019, the Singapore Academy of Law carried out a survey. There were 606 respondents, and 43% of them said that English law is the most frequently used governing law internationally in cross-border transactions. There was another study a few years earlier by the British Institute of International and Comparative Law that looked at 5 years, 2000 to 2015, 224 respondents, and 55.9, almost 55% of respondents agreed, said that they either had agreed upon or recommended English law for a cross-border contract. I also found it interesting that 76% of arbitration administered by the LCIA in 2021 included a choice of law in favor of English law. Now, many of these arbitrations would, of course, relate to a cross-border transaction of some kind. And there are also some academic studies across the years, really. I cite two here, one 2014 and one more recently 2020, that also confirmed that English law is the law of choice, possibly head-on with Swiss law. But very much ahead, for example, of French law, notwithstanding the fact that Paris is a seat of international arbitration, is quite actually close and really the closer contender to London, but certainly not French law. Lots of traps there, I think, as many of you are aware, particularly in relation to construction law, particularly if a French government entity is involved, but more generally, even in relation to contracts between private entities, and also very much ahead of the laws of different states in the US, particularly, of course, New York law is a business-friendly law, which is a serious contender, but then again, US state laws are much more complicated, much more intervention by the state legislature into these laws that is seen internationally as more risky. So then let's move on to the choice of English law in construction contracts themselves. So again, when I decided to give a paper on this topic, I had not appreciated that there wouldn't really be any empirical evidence or robust empirical evidence of this, or none at all. And perhaps that's something that the Centre should look at in due course. But certainly there is a lot of experience, certainly my personal experience and experience, I'm sure, of many of you here. And what certainly I would say is that whereas the law governing the main construction contracts, or the construction contract or the EPC contract for the dam or the nuclear plant or the pipeline, is often, not always, but often driven by the location of the project. So it would be relatively rare to see a nuclear plant built in, or a hydroelectric plant built in Brazil, the main contract governed by English law. However, what I have certainly seen, and I think it's the experience of people I talk to, and it would be interesting to hear from others, it's that actually all the surrounding contracts instead very often will be governed by English law. So starting with actually subcontracts and supply contracts. I have very often seen those contracts governed by English law, even in relation to projects in Africa, in South America, in Asia, and you name it, where the main contract is not governed by English law. Bonds and guarantees, obviously, again, governed by a law different sometimes from the law of the main contract, and this is English law relatively often. Joint ventures, consortia in relation to projects a little bit everywhere in the world. English law is certainly a preferred law there. That's certainly what one could observe anecdotally on the market. And the other thing that I would say, just anticipated perhaps a slight, to an extent, what I'm going to talk about later on in more detail, is that even if the contract is not governed by English law, nevertheless, the drafting of the contract, which may be governed by either German law, Nigerian law, or Brazilian law, or you name it, will have been heavily influenced by English law. So, for example, when you look at things like the role of the engineer under that particular contract, you wouldn't find in the legal tradition of many civil law countries the role and function of the engineer that you see in many contracts not governed by English law, which is, however, a role that is very familiar under English law, the role of the architect first and then the engineer, which we find in FIDIC as well. Very detailed provisions of notices, for example, whether it's time or notices to correct and so on. Description of the standard, the legal standard by which to assess performance. And so in very many contracts not governed by English law, you will find obligations such as obligations to carry out the work with reasonable skill and care in a workmanlike manner, fitness for purpose obligations that, again, very much resonate in English law, but they didn't have an immediate counterpart in many foreign jurisdiction or non-common law jurisdiction in particular. Limitation liability clauses that very often heavily rely on English concept or English law terminology, such as foreseeability, very alien as a concept to the idea of causation in many civil law countries, for example. Indirect consequential damages, loss of profit, fraud, gross negligence, and so on. And the overall approach is to drafting is often heavily driven by English law in the sense of having detailed legal provision covering the four corners so that the intervention of general contract law by the Italian or rather Brazilian or Spanish or civil code is as limited as possible. So why this preference now in terms of when the parties choose English law? Why has English construction law become a global standard in many ways? And I'm not suggesting, obviously, that it is the only standard or the only law that applies or even the absolute prevalent law, but it comes up with a certain frequency, that's for sure. Why is that the case? I mean, sometimes legal certainty is cited, but I mean, any law is certain and less certain to an extent, and I certainly wouldn't describe English law as certain or significantly more certain than many other legal systems. I would rather put it in a different way. Also, as someone who, of course, initially studied and trained and practiced for a little minor part of my career now, but in a civil law country. I would rather put it in a different way, and this way is that the English law strikes the right balance, or a rather good balance. There is probably no right balance, but a rather good balance between flexibility and inflexibility. Flexibility in terms of expanding as much as possible the scope of party autonomy, certainly when it comes to core commercial law or construction law, and inflexibility on the other hand, in terms of keeping parties to their bargain. The other thing that I would say is that English law, if you see certainty as a law where you can find solution, albeit some will require some significant degree of analysis and interpretation, and are solutions in the case law that may be open to debate. So there is no certainty there in terms of a kind of black and white or obvious, straightforward solution. But certainly, I would say that English law, because, as John Uff was saying earlier, construction law has become quite early on a distinct and separate discipline because of first the official referee's office and now for many decades now the technology and construction court. It is certainly easier in English law to find precedent in relation to the various issues that come up in construction law than it is in many other common law, and particularly civil law jurisdictions. And, of course, the spread of the English language and the familiarity with the common law itself. I mean, let's not forget that the common law applies in 27% of approximately 320 jurisdictions around the world. That, of course, does help to a significant extent. Of course, 320 jurisdictions are not 320 countries. You know, Australia, Canada, the United States have many federal states with many jurisdictions there. One question then, if there is some truth to what I have said so far, looking back at the history or the development of the international construction market in the past 20 years or so, let's say, I don't want to go further than that. One question that certainly has been asked over the past few years is whether Brexit has had or is going to have any impact on choice of law, on English law more generally, but let's focus on construction. Well, I think the anecdotal, little empirical evidence that we have so far, I mean, there was in 2020 a report by the City UK on legal services, more generally, not just construction law, but so far, I think there is no evidence that Brexit has had any impact at all, certainly as regards construction law or core commercial law. When I say at all, I mean any material impact, let's say. There may have been some impact at the margins, some impact in some cases or projects, but if you think about that as a matter of logic as well, obviously Brexit shouldn't really make any difference in the first place in relation to anything that happens outside the European Union. So why, in relation to projects in Nigeria or in Ethiopia or in India or Malaysia or Brazil, should Brexit really matter at all? I mean, some people, lucky them, they are only scarcely aware of Brexit. So, but even in relation to EU countries or EU parties, the benefits of English law really were not, I would suggest, materially dependent on the UK being a member of the European Union and therefore EU law being a part of English law. Perhaps quite the contrary. I mean, EU law, although its impact again into the core of contract law, once the project about a EU civil code or a EU contract law and so on and so forth have been more or less definitely consigned to history, to the history of legal thinking, the impact of EU law into a core contract law and construction law, I'm not talking about public procurement, labor law and so on, that are also relevant to the industry, was not very significant. But nevertheless, there was a perception and certainly a risk that English law could be influenced by a foreign and different approach. And I don't need to cite, for example, waste tankers in relation to arbitration and anti-suit injunction to say that the approach very often in Brussels, Strasbourg, and Luxembourg was not necessarily very business-friendly or, for example, very arbitration-friendly. You can even argue that the availability of anti-suit injunctions now, after the transition period has expired, makes London a more attractive arbitration seat, and therefore perhaps choice of law or choice of English law is more attractive than it was before. I'm not suggesting that Brexit was a good idea because of anti-suit injunctions, but it's certainly one of the Brexit benefits that we can perhaps see in our field. But let me move on to the third aspect of what I wanted to say, which is the influence of English law. So influence of English law beyond an express or implied choice of English law as the governing law of a given contract. And this influence, I think, is multifaceted. First of all, English contract forms are indeed sometimes used abroad. For example, JCT forms are used in Nigeria and in Singapore. And the drafting of those forms is obviously, I'm stating the obvious here, heavily influenced by English law, which is the jurisdiction where these forms come from. But even beyond that, if we look at FIDIC, for example, the FIDIC forms that are very widely used internationally, they carry, I think, a number of elements, again, that are very much influenced by English law. Now, historically, it is argued, one may say, that the 1957 Red Book was based on or heavily inspired by, and I think there are different views, and perhaps based on is not the politically correct thing to say, but that was inspired by the ACE form to a significant extent, and the ICE 1945 form before that. But of course, since 1956, a lot of water went under the bridges, and the FIDIC forms took on a life of their own in many ways. But I would suggest, again, as someone who has studied and initially practiced in a civil law country, that reading the FIDIC forms, I recognize much more of English law rather than I do in relation to civil law. Of course, surely the politically correct thing to say is that they strike the right balance between these different legal families. I also very often, this is just as an aside, I smile when people make these distinctions between the common law and the civil law, etc. I mean, I can assure you, as someone who has tried to study when I wrote my thesis in civil procedure, a German law. The German law is very, very much different from Italian law, as New York law is very different from English law. So what in the FIDIC forms you find, I mean, just two examples. I mean, in FIDIC, again, the role of the engineer is something that the dual role of the engineer who acts as the employer's representative in relation to his functions, but then when it comes to determinations, it has to act fairly, to make a fair determination, not on the instructions of the employer. That's very much, I think, a creature of English law. And similarly, again, the obligation in subclause 7.1 to carry out all that the contractor, or almost all that the contractor has to do in a proper workmanlike and careful manner that reminds us very closely of when Pierce and Tucker, if you want to go back to 1862, in relation to the obligation to carry out works in a workmanlike manner under English law. And just to conclude, there is perhaps even no need to mention the influence that the Construction Act has had on the payment rules and on adjudication regimes around the world. And this is not an influence in terms of statutory regimes, but also carries with it the influence of the case law of the TCC and the Court of Appeal in relation to adjudication. And principles of common law like the prevention principle, very much an English law concept that has been applied in Australia, in Singapore and elsewhere, and that has had an impact on things like the drafting of time clauses in contract and notice provisions that regulate time to exclude the application of the common law prevention principle as such. So my conclusion is really simply the following, that the central role of English construction law internationally, by no means exclusive or prevalent, but clearly central, has contributed significantly to making the centre what it is now, a global player in the international law, construction law market and international construction law space, and we will remain and shall remain faithful to that mission, to that objective, as we look at innovative models of procurement, the use of technology in projects and in dispute resolution that are the challenges that in terms of research, in terms of practical application that we face in the future. So remaining rooted in the internationalism, innovativeness of English law, but always looking, as we have since 35 years ago, at the global market. Thank you.
Thank you, Renato. Thank you, Renato. And so we turn for our last panel contribution to Mr. Justice David Waksman.
Just waiting for the PowerPoint to come on.
You just press this one.
Good, thank you. Thank you, Philip. Well, I'm extremely honoured to have been asked to participate in this special anniversary edition, if I can put it that way, of the annual conference of the Centre for Construction Law at King's College. Now, you'll see from the slide that the title of my contribution to this is the role of international courts in construction disputes. I'm, of course, entirely unqualified to speak on this subject. I'm not party to a construction dispute. I don't act for such a party. I'm not a user of those courts, and I'm unlikely to be so. But notwithstanding those small caveats, I think it has been possible to put together something of an overview of this subject, and I hope in a neutral fashion. And in the course of what I say, I will be building upon some of the things in particular that Renato has been developing in his presentation. So, by way of introduction, the question concerns international courts, and in one sense, what do we mean by that? Well, we mean any court that happens to be able to determine a dispute between international parties. Now, turning to the question of international construction disputes, as has been emphasized by John Uff today, they plainly require specialist tribunals because of their size, their complexity, their importance, and, as has now been emphasized, of course, the particular status of construction law as a field of law in itself. Some people have suggested, and I take this figure from an article in January 2022, there's been a 75% increase in the value of construction disputes worldwide between 2019 and 2020. Of course, when we talk about international courts, there are already domestic tribunals which satisfy the need to determine international disputes. And unsurprisingly, I turn first to the Technology and Construction Court, formed about 27 years before the Commercial Court, I should add, by the Judicature Act of 1873, so probably the longest surviving specialist technology court. The Judicature Act is sometimes known because it brought into play the fusion of law and equity, but of course that wasn't the real purpose. The real purpose was to establish the role of the official referee, which then developed into the official referee's determination of building disputes, and which eventually morphed into the TCC, as John reminded us earlier on. Because it is its 150th anniversary next year. Many of you will know we are celebrating it, and it's very fitting that I've been invited to appear today, because in this very building we will be holding a major conference in about 1 year's time. So the key point, of course, here is with these domestic tribunals, and indeed the other courts, the key thing is they will generally be prepared to hear an international dispute, provided both the parties to that dispute agree to give them jurisdiction. And that's usually the beginning and the end of it. So if you've got domestic courts which are fulfilling that role, if you've got arbitration, one then, of course, turns to the question, well, what is the particular role of the international courts as we now understand them? What is that they bring to the construction dispute party, if I can put it in that way? And much turns on which particular international court you are referring to. They're normally called international commercial courts, but nothing particular turns on that so far as construction is concerned. There are three different models. As I've said, there are the purely domestic courts in established jurisdictions, but which will take international business, and I refer to those as Model 1. There's Model 2, which I call the supra-domestic courts in emerging jurisdictions, which are designed to fortify and supplement free economic zones. They are Model 2, and it is that model that I will be concentrating on today. And then thirdly, there are other courts which are designed to further some international purpose. That sounds rather opaque, and I'll come to explain what I mean about it later on. So let's look at briefly Model 1 courts, the London Commercial Court, the TCC, the more recently established commercial division of the New York Supreme Court. Well, what are their features? First of all, they all apply common law, rather than a civil code system of law. Second, in general, as I've mentioned, if you agree them as the forum in which to have your dispute, that will be sufficient to found jurisdiction. They're English language, And to take the example of the UK courts, they are party to the Hague Convention. They are simply divisions or lists within the existing local or onshore court system. They all boast a strong, specialist, and entirely local judiciary. It's not in any way imported, and I don't mean that in any pejorative sense. Just to pick up on the Hague Convention, of course, there was a concern leading up to Brexit about the fact that the UK would no longer be party to the Brussels regulation on the recognition and enforcement of judgments, which in some quarters caused a concern as to whether work would depart the shores of the UK. In fact, it appears not to have done so, and the UK, of course, has now become a party to the Hague Convention on the recognition and enforcement of judgments as a party in its own right, as opposed to simply having been a member of the EU. If I then move to Model 2 courts, there are, of those courts, 3 particular variants, but they are all courts which I might describe as being offshore rather than onshore. Let's first of all say what they are. There's what I've called the Middle East group. That's the Dubai International Financial Center Court, 2006. It was founded, the Qatar International Court and Dispute Resolution Center, founded in 2010. The Abu Dhabi Global Markets Court, founded in 2015. Secondly, you have the Astana International Financial Center Court in Kazakhstan, founded in 2018. And then thirdly, we have the Singapore International Commercial Court, founded in 2015. So what are their general features? Well, again, they apply common law, in some cases imported in the sense that the local law of the region would not be common law. It might be a civil law approach, it might be something more individual, in some cases Islamic law. But the procedure that they have adopted has at least taken its root from the London Commercial Court. Again, for the most part, provided the parties agree to confer jurisdiction on those courts, that's sufficient to found jurisdiction. Sometimes there are other conditions, like the fact that the dispute is commercial and or that it's international. But those are 2 thresholds which are very easy to satisfy as far as an international construction dispute is concerned. Again, they will have a strong specialist and at least to an extent, an imported judiciary, that is, judges from other jurisdictions around the world who sit in those courts. And at least to some extent, they will be serving a relevant economic zone. So let's look at a little more detail at the Middle East group within the Model 2 courts. The 3 courts here operate to serve the free economic zones which those jurisdictions have established. The courts are a full jurisdictional carve-out, by which I mean that except in relation to certain aspects of enforcement, they are completely distinct from the local court systems operating in that area. So there is a jurisdictional as well as an economic carve-out. Now, what's the point of that? Well, the point is to boost the confidence of potential investors. It obviously makes sense when attracting investment to be able to assure the investor that should there be any dispute in relation to a construction project which is located in the zone, that there is an immediate tribunal which is suitable to their needs should a dispute arise, rather than them trotting off to another court in a completely different jurisdiction, or, it would be said, having to resort to international arbitration. So far as the DIFC and the QID CDRSC, all they require to take a case is that the parties agree to confer jurisdiction. So what that actually means is, even if the dispute is not centred upon a project within the free economic zone, it will still take jurisdiction. Although that was not the purpose for which it was founded, they see the sense in a global market. So far as the Abu Dhabi Global Market Courts is concerned, I've been told, the same is true there, but they are more centred on dealing with disputes that arise directly in their economic zones. So these are not local court systems at all. Well, of course, an important question then becomes, well, how do you enforce those judgments if you decide to litigate there? All free courts have regional treaties and conventions within the Middle East, but they don't belong to the Hague Convention. So generally speaking, if you wanted to enforce in Europe or in the UK, there would have to be a different route. In the UK, of course, that is done by simply applying for judgment on the basis that there is a foreign judgment which you wish to enforce, and the courts will generally recognize that unless there are questions of fraud or public policy or something like that. But there is no direct treaty. To mitigate this, what the Dubai and Abu Dhabi courts have done are enter into what are called memoranda of understanding, where they will say to the commercial court or the TCC, in UK, this is how we would enforce your judgment, and they say we will enforce it in the same way in our jurisdiction. So they've created mutuality, but it's not based on a treaty or a convention, and to that extent, it is less effective. Turning specifically to construction disputes, first of all, the Dubai court does have a designated technology and construction division, recently established. In 2020, 10 of its 123 cases were technology cases, and in 2021, 6 were technology cases. So far as Astana is concerned, that is to serve its individual economic zone, but it also sees a jurisdictional attraction in dealing with disputes from the entire Eurasian region. And it is open to take business from international parties, provided they agree to give it jurisdiction. Again, they have regional enforcement conventions, but it's not a party of the Hague Convention, and at present all the judges in that case are from the UK. Singapore is a bit of a hybrid case. It's got some Model 1 elements because it is a division of the Singapore High Court. It's not a separate offshore court. And the international court will take business that is generated through the local Singapore court, but it will also take business from international parties who give it jurisdiction. It's the court which has perhaps most tried to encompass a hybrid approach to procedure, bringing in elements of arbitration as well as standard practice, for example, from the English commercial court, and it's established a technology division, and you may well know that the head of that division is Sir Vivian Ramsey. The Singapore court is a party to the Hague Convention and is a party to treaties dealing with enforcement in Hong Kong and the Commonwealth. And there is a mixture of local and international judges. I'm going to be very brief because of the time. The Model 3 courts in a number of places, particularly France, Germany, and Netherlands, as a response to Brexit, they started their own commercial lists with added flexibility for English-speaking parties to bring their disputes there, but it's still civil code, but they will have English-speaking judges, and of course they're party both to the Hague Convention and the Brussels regulation. The last bullet point, please ignore, it is exclusively local judges. The intended but never fulfilled Brussels International Commercial Court would have included international judges, but it never emerged. Secondly, we have the China International Commercial Court, again designed to fulfill the potential it sees with its Belt and Road initiative and designed to take disputes from projects with which it is involved in that initiative. I've given you the name of two particular courts. It's part of the overall system. It's exclusively local judges, and you can't just agree to litigate there. Relevant law and procedure, well, that's obviously important in an international court. So one of the benefits is said to be it's common law, it's largely common law procedure. There are recognized and established judges from common law jurisdictions around the world. There are procedural rules which are optimized to make it managed in an efficient fashion, with facilities and technology, and they can take advocates like arbitration who come from all around the world, provided that they register with them. And there are some attractive costs points. Obviously, one of the functions they serve, and it's true for the international construction dispute, it's a better equipped forum for local disputes. In other words, it arises out of that economic zone. In construction cases, very often the construction dispute is actually about the finance for the dispute. It's banks, because that gives it its international flavor. But one of the advantages that it has is it's a TCC type approach. So if there's a problem on the contract, on the ground, which requires interlocutory relief, an injunction or declaration, there is a court in the area which you can go to immediately to have relief. I want to turn now just to deal with the key point, I suppose, which is, well, how does this all fit with international arbitration? Or does it fit? So where do we see the differences, or where are the advantages or disadvantages? Well, the ICCs tend to portray themselves as enabling speedy justice. Some international arbitrations can take time, even with the advantages of finality and little or no routes of appeal. But then on the other hand, it's been said an international construction dispute may take less time, typically in arbitration, in terms of number of weeks, than it might do in court. Confidentiality, of course, is one of the great virtues of arbitration, and in order to try and provide that, the Singapore court actually has an option of opting out of an open court hearing to deal with that very point. Having said that, of course, confidentiality can often be lost in an arbitration case if it goes on appeal and the decision is published. So that kind of goes both ways. Third-party action, it's often said that the court has the greater armory in terms of dealing with third-party orders or orders which the arbitrator cannot take, usually without the assistance of the court. So if you go to one of those courts immediately, you have those tools already there. Judges, well, in many cases, the judges nominated in the international courts also act as arbitrators. So to that extent, you know what you are getting. And some of them, of course, will have a particular expertise in construction disputes. What about costs? The ICCs, or at least some of them, will say they have a fixed cost regime and that the costs of the judges, as opposed to the arbitrators' fees, are very modest, they're reasonable, and they are certain. And of course, although there are many arbitration centers around the world, you will have a dedicated court building and your fees will include all the staff and technology, and that might be seen as an advantage. Although I've been told that in terms of recoverable costs, it's not going to make too much difference, whether it's in arbitration or in these courts, and some of the courts specifically will not have a facility for taxing costs. And many big construction players will just accept, if it's heavy litigation, it's just going to cost an awful lot of money, and there it is. Enforcement is another point. Some ICC awards may be seen as more susceptible of enforcement elsewhere than arbitral awards, because it's a court, not an arbitration. But on the other hand, there's the New York Convention, and much depends on the ICC court you are talking about and of course, critically, where you want to enforce the judgment. There was at one stage a scheme within Dubai that some of you may know about with the LCIA and the local Dubai court, where the local Dubai court would convert the judgment of the international court into an arbitration award. And then it could spin off down the arbitration enforcement route, which was controversial to some extent, but in any event, because of changes there, it doesn't happen in that way. And that's perhaps reflecting a view now that a court's a court and an arbitration is an arbitration. Or is it? Or are they? Of course, if you've got an arbitration clause in your relevant construction contract, as you often will, that's not necessarily an obstacle. It does mean that you will have to have an ad hoc jurisdiction agreement to give jurisdiction to those international courts. So where do the long-term benefits lie for construction disputes? Looking a bit beyond the practical matters I've addressed, it does, or it should, increase the jurisprudence of construction law, which we've talked about already today. There's going to be more public judgments. There's going to be more establishment of precedent, not necessarily binding technically in an English court, but particular construction law issues which may have been decided but never emerge as a piece of law because they're in arbitration, will now emerge in these courts. And I think that's a good thing going forwards. Secondly, absorbing the caseload. If it is the case that international construction disputes are rising in number as well as in value, they've got to find a home somewhere. You could radically increase the number of available arbitrators. You can't you radically increase the number of judges, I should say, at least not so far as the TCC is concerned, because, and it may come as a relief to you, there's only a certain number of High Court judges that can be in place at any one time, and that's by an Act of Parliament, and we are presently at our limit. So that's a possible way of absorbing the excess caseload, which would otherwise simply lead to delay. And delay, of course, is always the enemy of justice. It's particularly so if you have a blended approach like Singapore, or to a certain extent Dubai, which incorporates features of arbitration and/or optional mediation or other forms of dispute resolution which may attract themselves to the clients. Looking to the future, these are still early days because a client is going to be asked in an international dispute, do you want it to go to arbitration or to a local commercial court, or are you going to go to one of these international courts? The experience of litigators will be crucial going forwards. I think the real evidence in a long-term view will be to see the extent to which construction contracts actually change their arbitration and jurisdiction clauses. And that's a sort of major institutional shift, and it will remain to be seen whether that happens, or you are left simply with ad hoc references. But from my perspective, as a judge of a simple local court, I take the view that any increase in dispute resolution choices for international construction disputes is to be welcomed. I also take the view that although we've heard today how well the English common law has done in being exported to so many jurisdictions, that does not mean in any sense that what we do here is perfect. And just as those international courts can learn from us, equally we can learn from them. Thank you.
David, thank you very much indeed. Now, we've got many attenders online as well as those in the room, and I know that Renato would like to take at least a couple of questions. We are up against the clock, but I hand straight to Renato for that purpose.
Yes, absolutely. So any questions from the audience? There should be microphones. Or so there is a question there on the right-hand side, please.
Hi everyone, my name's Rebecca. I'm attending from Australia. I'm a PhD candidate at Monash University. Paula is my... Oh, you can't. I think I'm on, so I'll speak up. All right, that's too loud. Thank you. Professor Uff, you wrote two very interesting papers on whether construction lawyers should practice subject to an ethical duty, which was broader than to their clients and to the community at large. I wonder whether you might comment on whether the topic of your papers is still relevant today, and Kim, perhaps you could comment as to whether you think that should form part of the way we practice construction law in the next 35 years.
Why don't you go first?
Could you just say I didn't quite catch the tag that you were using. John's papers were on what?
Whether construction lawyers are subject to an ethical duty in the way that they practice.
Ethical duty. Well, we all are, aren't we? As a matter of natural justice. I'm not sure that as construction lawyers we have a particular ethical duty above and beyond any other sort of lawyer. Maybe John can give the background from his papers.
You're talking about a subject that was close to my heart. I wrote a paper, which I was delivered here as one of the Michael Brown lectures, on ethics in construction law. And I drew attention to the fact that all the different professional players in let's say, a construction dispute tend to be working under different professional rules. To take one simple example, disclosure. Lawyers have very firm obligations in relation to construction that can land them up in jail. Quantity surveyors, architects and engineers do not. So when you've got an advocate who's a surveyor or an engineer who's actually running the case, which often happens, chaos can develop if one side is giving disclosure and the other not. I suppose there's an innate sense of fairness in tribunals which would tend to incline them to ensure that there's the same sort of rule applies to each side, but that's just an example of something where you can get serious problems arising if it's clear that one side is intentionally withholding documents, which it might do with no sanction, because there are, what are the relevant rules? Anyway, you can look up the paper and read it.
I mean, it is, of course, remains very unfortunate that the bar rules around the world in different jurisdictions are vary very considerably on these kinds of issues. But on the other hand, the good news is that institutional arbitration rules in the last decade have started to move into this area with some success, and tribunals, I think, are much more attentive to it. Thank you all very much indeed, and thank you especially the panelists.